Hello, my name is Elizabeth Main. I'm an attorney with the Georgia Legal Services Program. I work in our eviction prevention project, and I'm here today to just give a basic presentation on the current state of landlord-tenant law in Georgia, and with basic information for tenants who are going through the eviction process or who may be facing the eviction process. This information is general. It is not specifically aimed at any particular tenant situation, meaning that if a tenant needs advice on their specific situation, they should consult an attorney. My agency provides free legal services to individuals who are low income. So if you would like to try to call our organization to see if you qualify and get assistance from us, I will have our intake information at the end of this presentation. And this current information is current as of October 12th. Sometimes there can be changes in the law, as we've seen previously with the CDC Order. So please do keep in mind, if you're watching this a month or two from now, to make sure you have up-to-date information. So to start us off, I'll start with the CDC Order, which was the eviction moratorium that was recently had been in place until recently. The Centers for Disease Control and Prevention issued an order that temporarily halted most evictions for non-payment of rent. This order was struck down by the Supreme Court on August 26th, and it was the U.S. Supreme Court. What that basically means is that the CDC order, which previously there had been a declaration that tenants had filled out to prevent their evictions for non-payment of rent from going through, that is no longer in effect. It has no meaning anymore. So, that's something to keep in mind. The order did not prevent landlords from filing for evictions. So the current situation we're in is that there were a lot of backed up evictions as landlords continued to file during the pandemic throughout much of Georgia, yet those evictions were not going through the courts. So there was a backup, and most courts are now working through that backlog. Now the CDC order did not prevent landlords from filing, and the only thing it essentially prevented was tenants from being removed from their housing. So some tenants are in various stages in the eviction process. Some tenants may be now coming up for a hearing on a case that may have been filed months ago. Some tenants may have had an order granting an eviction against them that was stayed because of the CDC order. Those evictions can now go through, and those tenants would be able to be removed from their housing without any further hearing. So as if a tenant is listening to this who had an eviction filed or thinks there may have been an eviction filed previously that was stopped by the CDC order in some way, the first thing you should do is contact your local clerk of magistrate court, and find out where in the process the eviction case against you was when it was stayed per the CDC order. Because again, if you've already had a hearing or if you did not file an answer into the case, you could be up for imminent eviction, and there would not be any further notice from the court or any further hearing before that would take place. It would be up to the sheriffs. So please do follow up with the court in that situation. Next, I'm just briefly going to talk about the courthouse responses to COVID-19. Your local courthouse's COVID-19 operating guidelines are posted online. There is a PowerPoint that I'm going through per this in this presentation, so that should be something that you can find online. I posted the link in the presentation. If you also just do a Google search or call your local court, you can find out those guidelines. In all counties, courts are observing social distancing. So in seating in the courtrooms and in seating in the courthouses, social distancing guidelines are being observed. Masks must always be worn. Most courthouses will also check temperatures at the door, and most courthouses have masks available for people who show up to court without a mask. However, I can't guarantee that that's every courthouse in Georgia, so please do be aware that you should bring a mask with you if you have a hearing or if you need to go to the courthouse to file something, or they may not let you in. And if you miss your deadline because you did not show up with a mask, there's no guarantee that the court will extend your deadline to file an answer or some other document, or will reschedule your hearing. Many counties are offering options for remote hearings. You must request this. The hearings are not automatically remote, and most clerks of court are not willing, and most judges are not willing to offer you a remote hearing at the very last minute, like 30 minutes before your hearing. It may be too late to request this. So you should contact, again, your local clerk of court as soon as you find out that there has been a hearing set in some case that you must go to court on, and as soon as you're aware that you cannot actually go to the courthouse for that hearing. Some things to know about remote hearings. Make sure everything is in place for a remote hearing at least 24 hours before the hearing. And that's good advice as well for just any hearing, even an in-person hearing. Make sure that you have everything you need for the hearing at least 24 hours in advance. Don't show up to court and realize you don't have all your paperwork or other documents. Specifically for remote hearings, if you're not using a computer set up at the courthouse, if you're using a computer or a phone or something from home or elsewhere, make sure you've checked the audio and video before the time of the hearing, and you can do that by, you can try calling someone else and seeing if they can see you and hear you. Make sure that you do that in advance, because if you just do not show up to your hearing and that was because of a computer problem you were having, that's no guarantee that the clerk of court or the judge is going to reset your hearing. You may have just missed your hearing, and at that point, the case would be over against you and you would not be able to go to court. Check with your local clerk of court in advance to find out if you need to submit evidence to the court that you want to show the judge before your hearing date. Sometimes judges will need to have that submitted electronically, or will need to have a paper copy brought to the clerk of court at least 24 to 48 hours in advance. And if somebody doesn't follow that rule and just tries to hold a document up to their computer screen or up to their phone, sometimes the judge will refuse to look at it because the person didn't follow the requirements for evidence. So do check that, because if you have rent receipts, police reports, videos or photos showing the condition of the rental property you're in, written communications between you and your landlord, text messages between you and your landlord, all of these are things that you may need to go through a process to submit to the court. You may not be able to just show up, show up virtually with them and expect that the judge will be able to look at them. And again, call the clerk of magistrate court in your county to ask how to do this. Every county has a different process, so just because one county does things a certain way, or your friend who lives in a nearby county had their evidence submitted a certain way, doesn't necessarily mean it's going to be the same for you. Make sure you talk to the clerk of magistrate court. The last thing is, if the clerk wants you to mail in a copy or submit a paper copy, do not give them the only copy that you have. The clerks of court are very good about not losing documents, but if something gets lost in the mail or if something does get misplaced at the courthouse, you don't want to have lost all of your rent receipts for the last year or something like that. Next, if your courthouse is not following their posted guidelines or is compelling you to attend a remote hearing that you don't have the technology to attend, or vice versa, if you absolutely cannot attend a hearing in person for whatever reason, you're in the hospital, you have been diagnosed with COVID and you're quarantining, please contact an attorney, and again, our information will be at the end of this presentation. So I'm just going to go through some general information about tenancies in Georgia. Tenancies follow under two categories. The first category is written tenancies. This is if someone has a written lease that has specific rules, guidelines, and a specific term for the tenancy, meaning it begins at a certain date and it ends at a certain date, usually 1 year. That would be considered you'd have a written lease. If not, if there's no lease, or there is a lease that states that it begins on a certain date and goes on indefinitely, or there's text messages where the landlord and tenant establish how much the tenant is going to be paying each month, but no term is set, you're going to have a tenancy at will. So this is sometimes called a month-to-month tenancy. The difference between that and a written lease is that the written lease will generally have is somewhere in the document will be terms under which the landlord or tenant can end the lease early if that's something that's permissible. If there's not a written lease, then a termination of the tenancy by the landlord would require a 60-day notice to the tenant. A tenant can terminate a month-to-month or a tenancy at will with a 30-day notice. Now, a 60-day notice does not have a specific. There's not a specific document under Georgia law that is considered to be a 60-day notice. It can be written, it can sometimes be verbal, it could be a landlord sending you a text message saying, hey, I want you to move out. It does not need to specifically say 60 days. The landlord could just say, I'm ending our tenancy as of today and I want you to move out, and then 60 days later they could file for eviction. The tenant does still have to pay rent during that 60-day period. That's something that we see frequently. If your landlord sends you a message saying, I want to end your tenancy, and you continue to pay rent for the next 2 months, and then they file for eviction, that does mean that they've done what they need to do to end your tenancy early. And again, a written lease would have the provisions in it regarding how and if a landlord can end the lease early. If the written lease says 60 days, then the landlord must provide 60 days in that situation also. In a tenancy at will, a change in the terms of the tenancy also requires a 60-day notice from the landlord. So if a landlord has decided that now animals will not be permitted at the property any longer, they tell you this and then they wait 60 days. Unfortunately, at the end of those 60 days, that change will go into effect, even if you did not agree to it. If you said, I don't want this, your option at that point would be to basically end the tenancy yourself. If a landlord gave a 60-day notice, they can change the terms of the lease. It also goes for rent increases. If a landlord says, I want to increase your rent by $200 or $300 per month, Georgia law does not have any limitations on how much a landlord may raise the rent. If the landlord gives the 60-day notice of rent increase for a month-to-month tenancy, then that increase is in effect, even if the tenant doesn't agree with it and tells the landlord they're not able to pay it. Both of these situations create a landlord-tenant relationship, both a written lease and a month-to-month tenancy, which means the landlord has a duty to repair and must use the dispossessory process to remove the tenant, which is just the eviction process through the courts, if they're going to physically try to remove the tenant from the property. So I'll go through the eviction or sometimes called the dispossessory process. The first thing that must happen is that a landlord must provide a tenant with a demand for possession prior to filing for the eviction. This can be done orally by just the landlord telling the tenant, you owe late rent, you need to pay by Friday or move out. That can be a demand for possession. They can also do it in writing and say, you need to pay within 2 days or I'll file for eviction. The landlord does not need to give 60 days notice that they're going to evict a tenant for failing to pay rent, because that would be considered a violation of the lease agreement, failing to pay rent. And so there does not need to be any specific time period. They just need to give that demand for possession before they file. The landlord would then go to the courthouse and file a dispossessory affidavit, which is a sworn document before the court stating that they have given a demand for possession and the tenant they're asking that the tenant be removed from the property for some specific reason, whether that's non-payment of rent, holding over beyond the end of their tenancy, or some other cause. The affidavit would also state how much, if any, is owed to the landlord for the tenant's failure to pay. If a landlord just specifically states failure to pay rent but doesn't specify, that's something that, while if the tenant owes money, that may not be able to be challenged in court, the specific amount would then be up for challenge in court, or whether the landlord would be entitled to a money judgment at that point. Service. The next thing that happens once the landlord files is that the court would then send the documents to either the marshal's office or the sheriff's office, and they would serve the tenant either personally in hand, which means that they come up to your door and hand the documents to you, or if they go to your door and they knock and no one answers, they can serve you in an eviction case by tack and mail, which means that the sheriffs can then post the summons on the door, the court paperwork on the door, and then also mail the tenant a copy to their last known address. And again, tack and mail service is not standard for most court cases. It is allowed in this specific kind of case. And if a tenant is served by tack and mail, the court cannot enter a money judgment against the tenant unless the tenant files an answer with the court. And the reason of this is a court procedure problem. If the tenant was never handed the paperwork in person and they don't file an answer, they can still be evicted, but the landlord cannot get a money judgment against them for late rent unless the tenant agrees to be a part of the case by filing an answer or by filing some kind of paperwork with the court into the case. So once a tenant is served, they have 7 days from the date of service to file an answer with the court. This is a very short time period, which is why it's very important if you're a tenant and you think that your landlord may be about to file an eviction, or they may, like you owe late rent, or in some way the landlord may be about to file an eviction. It's very important that you are checking at least once a week to, checking to make sure you've not gotten anything in the mail, nothing's been put on your door. Because if you, for example, go out of town for 2 weeks and come back and find that you were served 10 days ago, you've missed your answer deadline, and at that point, if you don't file an answer, there would be a default judgment against you, meaning that the landlord could get an eviction against you, and that could go through as soon as the day after the default judgment is entered. So if you've missed your answer deadline, it's a situation where you may need to be out very quickly, and you should call the sheriffs to find out how soon they've scheduled a set out, because that would happen imminently. The information on when and where to file an answer is located on the summons the tenant received. So the document that was handed to the tenant or posted on their door should have that information, and it's generally the clerk of magistrate court's office in your local county courthouse. The answer must deny, dispute, or challenge the claims of the landlord. If you file an answer just saying that I admit I owe this money to my landlord, I'm trying to pay, but because of A, B, and C reason, I lost my job, my car broke down, I haven't been able to pay, that is not actually a legal defense to eviction, and because of that, there could be a default judgment entered in that situation if the tenant did not raise any defense in their answer. The answer should also contain any claims the tenant has against the landlord, such as damages for failing to repair a property. If those are not listed in the answer, and the tenant brings them up in court and asks the judge to reduce the amount of rent that they owe or give some other remedy, it's possible the judge may refuse because the landlord did not have notice of that claim because it was not written on the answer. So again, it's just very important that the answer says every claim that the tenant wants to bring against the landlord. And again, there may be individuals who had an eviction filed against them months ago or even last year, and who filed an answer and are now waiting for a hearing date. So because of the CDC order. So again, if you were in that position, it's very important that you call the clerk of court and check on the status of the case that was against you. Because if you filed a CDC declaration, just because you filed that does not mean the eviction case is gone or closed. It may mean that it's now started to move forward through the courts. So because of COVID, tenants should contact the court to just double check if the court is open, if there's been any problems with COVID that have led to a closure, and to just make sure that the tenant can still file the answer in court. Most magistrate courts do not allow tenants to file online, but there's been some changes in a couple counties in Georgia about that because of COVID, so do check on that. And again, if an answer is not filed, the court will enter a default judgment against the tenant as soon as the 8th day, and the landlord will get a writ of possession. And if there was personal service, there would also be a money judgment against the tenant. So again, please do not wait till the last day to file your answer. If your car breaks down and you couldn't get to the courthouse before 5, that's probably going to be the end of the case. It's very, very difficult to get a judge to agree to allow a tenant to file a late answer. They're not required to do so. They're not required to give you an extension. So just be sure you don't miss that deadline. One of the most common defenses that we're seeing people use in the post-CDC order world is the tender defense. This is provided for under the Georgia Code. Basically, if a tenant pays all the rents that are allegedly due, including the late fees and the cost of the dispossessory warrant, unfortunately, within 7 days after they were served with an eviction case, that provides the tenant with a complete defense to the dispossessory affidavit. You can only use this defense once in a 12-month period. So any particular tenant, if you've used it earlier this year, it may not be available anymore. But that doesn't mean, if you can pay the rent, you shouldn't talk to your landlord and see if they would accept the money and dismiss the case. If your landlord accepts the money that you owe or accepts some amount of money that you owe and says that they'll dismiss the eviction case, you should still file an answer with the court stating that you made tender, and you should still go to any hearing set in the case. Do not assume that because your landlord told you you don't need to go to court for whatever reason, you actually don't need to go to court. Unless the court or someone at the court tells you otherwise, you still need to file an answer and you still need to go to any hearing, or there could be a default judgment against you. And again, we've had situations where a landlord deliberately misled a tenant to try to trick them into not going to their hearing. We've also seen situations where a landlord failed to communicate to an attorney that they had that the tenant had paid the money, and the attorney, without any other information and without the tenant being present, went forward and got a default judgment. So please go to your hearing, even if your landlord says, oh, I'll take care of it, you don't need to go. Confirm with the clerk of court before you miss your hearing. If a landlord refuses your tender, so you have all the money that you owe, including rent, late fees, court costs, you try to pay it, your landlord says, I won't take it, I just want to evict you. You should file an answer then, letting the court know that you had the tender and your landlord wouldn't take it, and either bring the money or a money order or some kind of document showing you had all the money on the date when it was on the deadline for the tender defense, which is your answer deadline. Bring that to court with you, or bring a photo of it so you can prove to the judge that you really did have the money and you still do have the money. What the court would then do is the judge would then allow you to pay your landlord and dismiss the eviction. The next slide is about retaliation. Before I go into that, I'm just going to briefly talk about non-repair claims. So if you have a claim against your landlord for failure to repair, the first and most important thing to know is that in Georgia, a landlord has the duty to keep the property in the condition it was in when it was rented. That means that if your landlord rented you an apartment that didn't have an air conditioning unit or had a broken air conditioning unit, unless there's something in writing at the time when you moved in or at the time when you started paying rent and started the lease saying that they were going to fix that and they had to fix that, they don't have the obligation to bring the property to a higher level of repair than it was in when you moved in. So just first of all, be aware of that. If you agree to move into a property that is in poor repair, you may not have a good claim against your landlord later on to get it into a better condition. There are limitations to this. If your county has a local set of ordinances that requires your landlord to provide certain things or to keep the property in a certain condition, but unless they're in violation of some kind of code of ordinances, then you may not be in luck with a claim for non-repair. However, if something broke in the property after you moved in and your landlord refused to fix it after you notified them, preferably in writing, that they had the obligation to do that, you may be able to ask the court to reduce the amount of rent that you owe based on how severe the repair condition was. In addition, if you request repairs or if you take action to secure repairs in any way from your landlord, you call code enforcement, you file a lawsuit against your landlord to try to make the repairs, you may have a claim if your landlord then files an eviction case against you because you asked for the repairs or because you sought code enforcement's assistance. If a landlord takes adverse action against a tenant within 3 months of the tenant's actions for repairs, it's presumed under Georgia law that that was in retaliation for the landlord seeking repairs. So even if they didn't say, I'm evicting you because you requested repairs, if it happened within those 3 months, it's presumed to be retaliatory. And you can raise this as a defense in your answer. So just, again, that just means write in your answer, I asked my landlord for repairs on such and such date, and 2 weeks later they filed for this eviction. I'm claiming that this is retaliatory. Now there are obviously, once you've shown that, the landlord can then come back and show the judge that they had some other legitimate reason for filing for eviction. And if they do prove that it wasn't retaliatory, it's because you didn't pay rent last month, then you can still be evicted and you would not have a claim for retaliatory eviction. Tenants cannot withhold rent in Georgia for a lack of repairs, and that's something that we see frequently that we're hoping tenants will stop doing. In many states, you can do that, but in Georgia, if your landlord didn't make repairs and you didn't pay rent, you can be evicted for failing to pay rent. Now, the rent might be reduced because the money judgment against you might be reduced because your landlord didn't keep the property in repair, but you would still be evicted for not paying the rent. So please do not withhold rent because your landlord didn't do repairs. You can take legal action against them, but you cannot just withhold rent. If it is shown that the landlord was retaliating for a tenant's attempt to secure repairs, it's a defense to the eviction. The landlord cannot evict the tenant at that point, and the tenant may be entitled to money damages of 1 month's rent plus $500. So whatever the amount of the rent is, and then $500 in addition to that. So once a tenant files an answer, a hearing will be scheduled by the court very quickly after the answer is filed. Now, in some counties, there are delays because, again, they are working through a big backlog of cases from the last year and a half. But some counties have now at this point almost caught up or are caught up with those cases, so it could be that your hearing would be scheduled as soon as a week or two after you filed your answer. The court hearing is an informal process. It moves pretty quickly. It is not, it's going to be the court will call you in. They'll ask the landlord, why are we here? Why have you filed this eviction? The landlord will answer in a couple sentences. The judge will say, okay, what's your defense? Why didn't you pay the rent? And that's your chance to bring up any claims you have. So you should be prepared ahead of time to be able to give the court a succinct explanation for what your defenses and your counterclaims are, usually in about 3 or 4 sentences, as quickly as you can so that you can get that before the judge. If the court rules for your landlord, the court will issue a writ of possession, allowing the tenant and their property to be removed from the rental home. Usually the tenant will have 7 days to move out, because the appeals process is that either party can appeal the court's judgment within 7 days of the eviction hearing. So usually the court will give the tenant 7 days to move, so that if they want to file an appeal, they can do so. If the tenant doesn't appeal within the 7 days, the action would then go to the sheriffs, and the sheriffs would schedule a time to set the tenant's belongings out. So once that writ of possession is issued, if there's no appeal filed, the tenant should be prepared to move out as soon as the 8th day, or they could be, their belongings could be put on the side of the road. And at that point, if your belongings are set out pursuant to a court order, your landlord does not have any responsibility for their condition, for making sure that they don't get rained on or stolen or anything else. Once they're on the curb, it's out of the landlord's hands. So if a tenant wants to file an appeal, it is, unfortunately, if it's a non-payment of rent case, it may be outside the tenant's ability to file an appeal in some cases. To keep possession of a rental property while the appeal is pending, the tenant must pay the amount that the court found to be due for past due rent, and they must pay rent going forward each month while the appeal is pending. So what that means is, if you don't have this money, you can still appeal, but the tenant cannot remain in the property while the appeal is pending. So for example, the tenant could appeal the amount of the money judgment and say, I know I owed late rent, but I don't believe the court was correct when it found I owed this amount of money. It should have been a lesser amount. You can do that without paying the rent into the court registry, but you would also have to move out. The writ of possession would go forward, and if you don't move out, your things could still be set out, even though an appeal is pending. In addition, the courts can charge a fee for filing appeals. However, if a tenant is not financially able to pay this fee, you can request the fee be waived by filing a pauper's affidavit or a poverty affidavit. Some courts call it different things, but you can file a waiver of the court fees, and that's not necessarily a waiver of the monthly rent amount. If you want to stay in the property, it's just a waiver of the fees that the court charges for filing an appeal. So that is, in general, the situation of housing law in Georgia at this point, post CDC order. Again, in most counties in Georgia, the evictions are proceeding as usual. There are some states around the country that have statewide eviction moratoriums, but Georgia is not one of them. So, please be careful when you're looking up information online that you're not looking at some other state's information about their eviction moratorium. There's not one in Georgia right now. Several counties in the Atlanta area have their own eviction moratoriums, but again, those do not apply beyond the borders of those counties. So in most counties in rural Georgia, evictions are proceeding as they were before the pandemic began. The last thing I just wanted to quickly cover is some housing scams that we've been seeing that we're hoping tenants can be aware of and try to avoid. The first is a scam connected to utilities. Utility companies are not going to call you to ask for payment over the phone. If someone calls you claiming to be a utility company and saying that your things or your lights or whatever are about to be cut off in 8 hours if you don't pay such amount of dollars, tell them you'll pay online, and then contact your utility company using contact information from your utility bill. Do not take down a website information or a phone number from someone that called you over the phone and then contact that, because it's probably just a continuation of the scam. Use your utility bill, find that website or phone number, and pay or get more information using that information. While you're searching for new housing, do not provide personal identifying information or financial information to someone in order to reserve a property that's being advertised for rent. What we've been seeing is that someone will post information or photos of a property that maybe they don't even own, maybe they don't even have a right to. They'll post that online, and then they'll take someone's bank account information in order to pay a reservation fee or in order to hold the property or do a credit check or something like that. And then what usually happens is that the bank account is emptied and the tenant is never able to find the person that said that they were renting the home. And it turns out, the home is probably belongs to someone completely different. So please be very careful about providing financial information to a landlord, especially someone that is not part of a company that has a legitimate business address. If it's just some individual, be very careful about giving them your information. Make sure you have a good physical address for your landlord before you start paying them money. If your landlord is coming by each month to collect your rent and you don't actually know their last name or their address, or you just send the money to a P.O. box and you don't have any identifying information, please be very careful. Please try to check up and get more information in that situation. Because if, for example, someone takes a security deposit and first month's rent and and then just disappears and they never gave you house keys, or it turns out they didn't have a property rent to you at all, you need to be able to let the police know or a court know where they are so that you can actually try to get that money back. Because if you just had a first name and now they're gone and you don't know where they can be found, that money is probably gone and can't be recovered. While you're facing an eviction, evictions are not a criminal matter. If someone calls you claiming that if you don't make a payment to them, by phone or by online or in some way, you will be arrested for not paying your rent, or you're going to go to jail if there's an eviction case against you and you might be incarcerated. That is not true. Do not believe them or give them any of your financial information. You can never be arrested as part of an eviction case. You can't be arrested for not paying your rent in addition. So just be very careful about that. So that's all the information I have today. Again, there is a PowerPoint that goes with this presentation, and I did include our information on the last page of that. I'll give you the phone number right now for our Georgia Legal Services Program intake. Our number is 1-833-457-7529. Again, you can call us for legal assistance. If you need rental assistance, the Georgia Rental Assistance Program that's the statewide program that Department of Community Affairs is running that has a large amount of rental assistance to give out. You can find that program at georgiarentalassistance.ga.gov. You can apply online at that website. I will say for rental assistance, if you have any trouble with applying, you can call our Georgia Legal Services Program intake line. We do have housing navigators available who can assist tenants with filling out their applications. There is also a portion, if you're going to apply to this program, there is a portion of the application that the landlord must fill out. So if you're having trouble communicating, reaching your landlord to try to get them to do this, again, please call our number and we may be able to assist with trying to reach out to your landlord. And the last thing is, please be aware that this program, it does take some time to pay rental assistance. It's not like going to an ATM. Once you apply, we've usually seen it take between 1 to 4 months for money to be paid out. So if you know now that you owe October's rent, it's now October 13th today. So if you're aware that you owe October's rent and you're going to need assistance, don't wait for your landlord to file for eviction. Apply now, and hopefully that will mean that once they're ready to file for eviction, your application will be further along in the process and you may be able to be paid before your court date. So that's the information I have for you today. And again, please call us if you have any other questions. Our number is, again, 1-833-457-7529. And you can also go to our website at glsp.org.